I know many of you in the last 24 hours or so have asked us the question here on CWR, how are we allowed to broadcast this? These allegations labelled at high-profile public figure without any formal police charge being made, certainly not so far anyway. Matthew Claughton is the Managing Director of Olliers Solicitors, specialises in rape and sexual assault cases. He is himself a lawyer, joins me this morning on CWR. Matthew, morning to you.
Morning, Phil.
Appreciate you coming on this morning. Lots of people would have seen the Channel 4 Dispatches programme, might have even have read the articles in the Times and the Sunday Times, either online or read them in the newspaper themselves. How are they able to make these allegations so publicly, you know, with such headline grabbing attention without actually charges being brought before Russell Brand?
I think the starting point is that they can report this. This is ultimately a judgment call for their media lawyers and the laws of defamation. And it's ultimately a matter of the journalistic integrity of those involved. So from that perspective, yes, they can report it. The question is what the implications would be for a future police investigation.
I suppose when you have reporting as widespread of this, you know, if there are charges and then ultimately, I suppose, you know, any kind of trial, there are dangers, aren't there, in prosecuting that, because the public may potentially have made up their mind. You'll never be able to get a proper, you know, set of jurors together, would you, to judge on this if already this is such open and closed?
Yeah, if this matter were to be prosecuted, there's no doubt that a defence team would argue that there was no way that their client could have a fair trial and that he'd already been tried in the media. And that would be an abuse of process argument. That's the danger that the Dispatches team and Channel 4 team, that's a risk that they run. And they must have thought about that before publishing and broadcasting.
Yeah. It's a general question, I suppose, Matthew, when we deal with these stories, how difficult does it, I mean, in your case, as a lawyer, to defend your client facing criminal charges of this nature? If Russell Brand was your client right now, what would you be doing?
Well, it makes it a lot more complicated because there's such a complicated history to the investigation. Ordinarily, if the police receive a complaint, they get an initial account from a complainant, then a specially trained officer, as distinct from an experienced journalist, a specially trained officer interviews a complainant in a recorded interview, and there's no room for criticism of the process, or very limited room, and the integrity of the process of capturing evidence can't really be criticised. What we have here is the polar opposite of that, because we have an investigation that's gone on for, I believe, many years. And in that situation, there will be lots of room for criticism of the process in which the evidence was captured and different versions of events were obtained. And it's not just the defence. The police will want chapter and verse about what's happened in the build-up to any police complaint. Right. The prosecution, the Crown Prosecution Service would want the same. And then during the course of the investigation and later, so would the defence team. It would make it harder.
Sure.
Sorry.
No, it's all right, Matthew. I was just trying to understand again from, you know, you've given a defence position there from I mean, we've heard the Metropolitan Police this morning, for example, now have got involved because of complaints that have come in subsequent to the broadcast of the Dispatches programme and the articles in the Times or the Sunday Times. What requirements are there in a sexual assault case that have to be established before a police force can press charges against an individual?
Okay, the test is whether or not there's a realistic prospect of a conviction. And so they will have to look at the versions of events that come from complainants. They would also have to look at the risk of a successful abuse argument for post-charge. But is there a realistic prospect of a conviction? And the defence may well make representations against charge during the investigation process, and they may draw attention to inconsistent version of events that have been made to journalists throughout the process. And what the defence would want access to is all the material obtained by journalists and the contact between journalists and complainants during the period of the investigation. And they would be looking to establish contradictions in the complainant's version of events so that they could argue that there is not a realistic prospect of a conviction here.
Matthew, appreciate it. Thanks very much indeed. Matthew Claughton from Olliers Solicitors, specialising in rape and sexual assault cases. That's the legal aspect.